Hi, Frank Gray, attorney with Chesapeake Wilson Trust. Here today to talk to you about a question we get sometimes. Can I write my spouse out of my will? Or put another way, can I keep my spouse from getting everything when I die? A question we get sometimes from clients is, what can I do to make sure my wife doesn't get everything? Or they'll even go a little more extreme and they'll say, can I write a will or an estate plan to make sure that my wife doesn't get everything? And the first question I have to ask is, do you have a prenup or a postnup? In other words, did you sign an agreement before you got married or a separation agreement after you got married where you agreed that that would be a permissible thing to do when you created an estate plan to make sure the spouse didn't get what they would otherwise be entitled to? And if the answer is yes, then my answer is yes, we possibly can. If the answer is no, and for most people it's no, then the answer is you really can't write your spouse out of your estate plan because of what's called Maryland's Elective Share Law. It's a relatively new law that came into effect in October of 2020, and it replaced an old law. The public policy of Maryland has always been that they didn't want people to be able to write a will so that they left their spouse nothing. But honestly, prior to the new law, it was really easy to do. So effective October 2020, the law changed to expand that public policy. What the elective share law does is it basically allows the surviving spouse to make a choice between what's called the elective share, which we'll talk about in a second, and what they were left by their spouse at the time of their death, either by a will, by a trust, or through those non-probate assets. The payable on demands, the beneficiaries of the 401ks, the titling of the house with joint tenancies, things like that. To decide how much of the elective share you might be entitled to get, the question is, did the decedent have children? If the answer is yes, then the surviving spouse would be entitled to 1/3 of those assets. If the decedent didn't have children, the surviving spouse would be entitled to 1/2 of those assets. But to exercise your right to elect that marital share or that spousal election, it requires some action on your part. You don't automatically get that. You have to voluntarily make the election, and here's how you have to do it. Number one, the election has to be done in writing. Number two, it actually has to be signed by the surviving spouse. And number three, it has to be filed in the appropriate court within 9 months of the decedent's date of death or 6 months after the appointment of the first personal representative of the estate once the estate is opened. As always, thanks for watching. Click down below to download your free probate guide. Make sure to like this video, hit subscribe so you'll know when we push out more content to help you with your estate planning needs in Maryland.